Legal practice generally is an art, and art is practice. The art of football, for example. I think many of us are football fans because of what we see the players do in the field. When you go to watch football and you watch players like Agustin JJ Okocha or Lionel Messi or Ronaldo or Ronaldinho, there's something that attracts you. It is because of what they do in the field. And I believe that Lionel Messi did not sit in a lectured by the best football professors in the world, from which he became the dribbler that we know him to be. I think he took onto the field, tried out those skills that we admire, got them wrong, tried them again, improved slightly, tried them again, improved averagely, tried yet again, improved significantly, until today, when we think he's a near perfect footballer. And I'm giving this anecdote to demonstrate the distinction between practice and theory. That any skill that is artistic in nature requires consistent practice over time so that you internalize the skill and the skill becomes, what I say elsewhere, second nature to you. It becomes so embedded in you that it is associated by you, by anyone who knows you in that field. And talking to our learners in particular and the young legal practitioners who may be following us online, never give up. You start it off, you make elementary mistakes. You try again, you improve marginally on the elementary mistakes. You try yet again, you make further improvement, you become average, then over time, you become above average, and people may thereby think that you are good at what you do, but truth of matter is what makes you appear to be good at what you do is a product of consistent, ceaseless practice that does not admit the spirit of despair. I trust I've tried to answer your question, but I could clarify in areas where you think I may need further clarification. Over to you.
Yes, you've done. So to the next question. What role does body language and demeanor play during cross-examination in Kenyan courtrooms, and how can advocates use this to their advantage?
Thank you. And maybe I should have cautioned my audience that I'm not very good at answering questions. I'm good at asking them. And therefore, if I look a bit funny, they should understand that I'm in a very unfamiliar territory. But having said that, trial advocacy generally, as I've said, is an art and is an art of persuasion. The trial process entails a fact finder dealing with two or more versions of the same story and having to decide at the tail end which story to believe and which story not to believe. In fact, I dare tell young lawyers, those who win cases in a good, corrupt-free and legal environment are not necessarily those who are speaking the truth. It is those who are more persuasive. It's those who are believed more. The fact finder, in our case, a judge or magistrate or member of a tribunal, in other jurisdictions, a member of the jury, will make a finding in favor of the side that was more convincing, that was more persuasive. And therefore, all tools of persuasion become useful in the trial process. One of the tools of persuasion is body language. I trust in our day-to-day lives, there are people we listen to when they're trying to explain themselves and we don't believe them. Just because of the way they conduct themselves. They look itchy. They look like they don't believe their own story. And I've warned the people elsewhere that it is impossible for others to believe you if you don't believe yourself. So you must have some faith in the story that you are saying, and that will manifest itself in your body language. Are you looking sufficiently confident? Are you looking sufficiently credible? Do you look like you have read your story back and forth and you have internalized it? Have you owned your story, if I may? So I would summarize by saying body language plays a central role in communication generally, in storytelling, and therefore in the art of persuasion. And therefore, as young lawyers like the audience I have in this room try to perfect their trial advocacy skills, for those among them who may aspire to be trial lawyers in the future, one of the areas they will need to work on is body language, eye contact, how they speak without having to chew their lips or to scratch themselves a little longer for a point that has disappeared, how to speak coherently and consistently without looking like they are looking for words from their longest term memories, and so forth. So those things will help them in advancing their persuasive skills to a significant degree. Allow me to finish by saying, I have told many people who listen to me that 30% of every contest is psychological. If you psychologically win a contest, you are 30% in the struggle. You have 70% to go, which is why there is no rugby team that is called the Butterflies. Because if you take onto the rugby field calling yourself the Butterflies, psychologically you look weak. Rugby is not a sport for the weak. It's a sport for the most abrasive, perhaps those who look more violent. And therefore you take onto a rugby contest violent even in name. Names of rugby teams look violent. They call Red Devils, for example. You look violent by calling yourself the Red Devil. I schooled in a university where the rugby team was called the Mean Machine. Mean Machine. You look violent. You look oppressive. And it's in the nature of that environment that psychologically you must look like that. So I want to finish once again by telling our audience that yes, you must perfect, you must continuously improve the way you present yourself in terms of body language if you intend to be persuasive, which is a critical element of the trial process.
Thank you. Let me move on to my next question. The audience also, you prepare to ask as I open the floor to you. So my next question is, how do you balance between being persuasive and maintaining a respectful tone, especially when challenging a witness credibility?
In fact, contrary to popular view, and I think many people will be very surprised, you can only be persuasive by maintaining a respectful tone. What is respectful is a question of fact, dependent on the circumstances of each case or each situation. And therefore, it is a poor trial advocacy tool to actually humiliate and intimidate witnesses. Because when you are dealing with a witness, either you're dealing with your own witness, in which case you are examining them in chief or re-examining them, or an adverse witness, in which case you are cross-examining them. That process of examination is an integral part of the storytelling process. And if you are dealing with an adverse witness, it means you are telling your story, your own story, through the adversary. And the only way is to make them buy into your story slowly and incrementally, and knowingly or unknowingly begin narrating your story, your version of the story. So your primary endeavor as a trial lawyer should be always to show optimum respect to the adverse witness. I am not sure whether I have done well in that area of practice. My students certainly would exhibit substantial doubt if I suggested that I have done well in that area, but that shows that we are all work in progress. It's an area I'm still trying to study in, hoping that before I retire, I would have made significant progress. So yes, there is no room for rudeness to witnesses or being mean to witnesses. At every stage, you have an obligation to be respectful to your own and adverse witnesses.
Okay, last one more question. Then I think any member from the audience here, you can raise up your hand and ask a question. So how do you handle situations where a witness unexpectedly changes their testimony, and what techniques allow you to redirect the questioning effectively?
Allow me to say something about witnesses generally so that this answer is understood. Trial lawyers and scholars in the trial process, there are two Indian scholars who have done a book. The book is called Aya and Aya, The Art of Cross-Examination. I commend that book to any law student and lawyer who desires to manifest significant expertise in the trial process. The book is called The Art of Cross-Examination, authored by Aya and Aya. That author identifies various types of witnesses. And when you go into a trial, you must make up your mind the kind of witness you are dealing with. Number one, there is the truthful witness, just speaking the truth. That, to my mind, is the hardest witness to deal with, because truth defends itself. Truth has a way in which it speaks for itself. Truth does not require justification. There is the lying witness. That's the easiest witness to confront, because sustaining a lie is a difficult and monumental task. It is not easy to sustain a lie. And therefore, if you're a good trial lawyer, when you deal with a witness who is lying, you have a field day. There is the coached witness, the witness who is telling a story, but this is not their story. They have been given this story by a third party to come and regurgitate. Like a lying witness, that's a very easy witness to deal with and discredit. There is the expert witness, a witness who comes to court as a dispassionate speaker of their expertise. So you come to court and you say, I am a ballistics expert, and I have done an analysis of this firearm and this round of ammunition, and I want to tell you whether this round of ammunition was discharged by this firearm or not. Or I am a pathologist. I have carried out an autopsy on this body, and I want to tell you something about the cause of death, what could have caused this death. Or I have examined the blood sample here, and I want to tell you whether the deceased had alcohol in their blood or not. As a lawyer, you must confront those witnesses differently. If you confront these witnesses as if they are one and the same witness, you're going to have a long day at the trial as a lawyer. So it's important to know your witness before you even take on the stand. The advantage of the trial process in many jurisdictions, ours included, is it frowns upon trial by ambush. It therefore means that the story that the witness is going to tell you has already been furnished to you, either by way of a witness statement or by way of a witness affidavit. So you already know their story, and therefore you have an idea as to whether they are lying witnesses, truthful witnesses, expert witnesses, among other typologies of witnesses. And once you read Aya and Aya, there are more than 50 different categories that are not mutually exclusive. So you must categorize your witness appropriately. Now, since you have already read the statement of the witness, there are certain expectations that you expect from this witness. You have their story, but some of them may want to depart from this story as written down in their affidavit, or as written in their witness statement, or as already narrated in their evidence in chief, if you are cross-examining that witness. This is where various tools of cross-examination come into play. When you are cross-examining witnesses, one of the tools of cross-examination is what we call one fact per question tool. You frame your question in such a manner that your question seeks the witness to give only one fact. Now, you notice that a lot of people frown upon lawyers' use of what you call yes or no answers. But we use those kind of questions because those questions seek to establish only one fact. It's been said elsewhere that whereas every person is entitled to their own opinion, surely a fact is a fact. If I ask you what time it is now, that's a fact. You can't tell me in my opinion it's midnight. You begin looking foolish. The time that it is now is a fact. You can't have your own version of that fact. There are some facts that may have their own versions, but those are explicable scientifically. For example, if I ask you for the color of this bottle and you are colorblind, chances are you may have your own version of that fact. But that can be explained. That can be explained by you telling us, I am colorblind generally, but looking at the tools at my disposal, that color appears to me to be, we'll understand in context because the fact in question is dependent on your capacity to see the color properly, scientifically speaking. Giving latitude to those outliers, the core of facts are just facts. So you remain within the realm of facts in cross-examination by seeking one fact per question and avoiding compound questions. Compound questions are questions which attract more than one fact by the same answer. If I ask you a question, for example, what time did you arrive and what did you do when you arrived? That question is seeking two distinct facts. The time when you arrived as a fact and what you did upon arrival. As a good cross-examiner, you must ask them as two distinct and separate questions. What time did you arrive? And you keep quiet. This question seeks only one fact, a question of time. You may agree or disagree with the answer that the witness gives, but that answer must touch on something called time, which we all know what it is, if we are men and women of good sense and logic. Then the second question will follow, what the witness did upon arrival. So you avoid framing that question as a compound question, as a question seeking both facts in the same question. A lot of trial lawyers get it wrong there, where they try to seek multiple facts from one question. That way, the witness can take you around in circles. The third tool that we use is by using questions that suggest the answer to the witness. The question itself suggests the answer to the witness. We call those ones in evidence law leading questions. In fact, as much as possible, a trial lawyer knows that whereas at cross-examination stage, you are permitted to ask leading and non-leading questions, as a general rule, you will use only leading questions in cross-examination. Because that's the only way you control the narrative you want to come out. You are the one in control of the story that is coming out. Because by virtue of this being a cross-examination, you are dealing with an adversary. You are dealing with a witness for the adverse party. And if you allow them to take control of the narrative, then they will lead you wherever they want you to go. But if you remain in the control of the narrative, then you will lead them where you want them to go. And you can only remain in control of the narrative by posing only leading questions. And the only opportunity available to the witness is to confirm your answer or to deny it. In which case, then you will ask follow-up prodding questions to be able to get where you want the story to go. The final tool I'll talk about is the tool of control of the witness. We control witnesses using various common sense tools. For example, you can use your body organs. When you put a hand to the witness, he knows now stop there. He will stop. Or just direct him to stop. Or tell him my question is fully answered. Allow me to pose the next question. All these are tools of trying to control the witness. The other tool of controlling the witness is by asking the same question in reverse order. So you tell the witness to confirm that this bottle is blue in color. The witness wants to begin explanations. You tell him now to confirm this bottle is not blue in color. If he says this bottle is not blue in color, you looking at it will know he looks foolish. So you pose the question in such a manner to make the witness look funny, whichever way he answers it, directly or in the reverse. Or you pose other questions to remove all other possibilities, then remain with only one possibility. So you say, this bottle is blue. He says, no, he begins explaining his own thing. Say, no, this bottle is not white. Says it's not white, it's not green. So you remove all other possible colors. Then you come back to where you wanted. So confirm it is blue. That way, since only one option is remaining, if he tries to explain himself around it, he also begins looking funny. And by word funny, I mean foolish. So that's how you go about it in getting witnesses, answers from witnesses who try to become evasive in their answers. Yes.
Thank you. Yes, now we can have questions from the public and also from our online audience. You can either type your questions in the Q&A or you can raise your thumbs up.
Thank you very much, Jabez. I believe we're cruising on nicely, and this is truly an eye-opening session. I encourage you to make the most out of it. Mwalimu here is clearly a fountain as far as the art of cross-examination is concerned. So I want us to guide on how we're going to take these questions, if you'd allow me, moderator. So Jabez here will pass the mic to the audience on this side, and she will pass the mic. Please be upstanding to the audience on this side. And thank you very much, all of you 356 online members for joining us. We are also quite full here. I think at some point, Stanley, you should, yes, pass the mic around. No, the camera. So Jabez, the 3 questions from this side, 3 questions from this side. I'll read out 3 more questions. Then we can take it back to you, and then we can take it again.
Thank you.
Thank you very much.
So first and foremost, I would love to appreciate you taking the time to hold this event in furtherance of our skills in trial advocacy. Recently, not actually that recently, but a debate has been going on that advocates do not represent the morals of their clients. Should the allegations that were posed before the Senate be confirmed to be true, what does that mean for your credibility as the advocate to His Excellency, the former Deputy President? I wish not to compound my question. Thank you.
So thank you. Hamjambo.
Hatujambo.
So I have a question. From when I was a great follower of the impeachment process. And what I noted is that we do have 2 types of cross-examinations. We have the direct one, where you are expected to give a yes or no answer. And we have the one that I will call constructive. You give your own narration, then you seek to get an answer from the witness. So from the 2, which one is the most applicable and under what circumstances? Thank you.
Okay, my question reads, how does one prepare their witness during TV examination, even if the evidence presented before the court is not in support of the case? Yeah.
Good afternoon.
Good afternoon.
My name is Ruth Jabet, and first of all, I'd like to say that it was quite exhilarating to watch you throughout the whole processes, do the cross-examination and give your opening statements, also ask for more time. So it's really interesting. So I just have 2 questions. The first one is, you have said that in order to be a good litigator, you need to have a spirit that does not admit despair. But when you're dealing with a case whereby that is mad with political interests and corruption, as you've named it, how do you maintain that spirit that does not admit despair? The second question is there a difference between advocacy before international courts, regional courts, and advocacy before national courts? Having been a litigator before the East African Court of Justice and also a hypothetical litigator before the International Court of Justice during your student days. Thank you.
Okay.
Thank you so much. My name is Karen Mudei, and I have 2 questions. how do you prioritize what questions to ask during a cross-examination, provided there's limited time? And what are some of the common mistakes that you've seen counsels make during cross-examination, and how can they be avoided? Thank you.
The first 3 questions from our online audience, one by Banis. She says, my question is this: what does a great cross-examination look like? What is the position of silence and questions? The other question, anonymous attendee, in your experience, what are the most common mistakes lawyers make during cross-examination, and how can this be avoided? Lastly, for now, how do you approach preparing for cross-examination, and what key elements do you consider essential for building a compelling line of questioning? Hope you captured this, Malim.
Yes.
Okay, over to you.
Thank you. This session was poetically entitled Examining the Cross-Examiner. I presume that I was the one called the cross-examiner in that poetic title, and that you are the ones called the examiners. I told you, if you call me a cross-examiner, then you suggest, rightly so, that I'm not very good at answering your questions. To the extent that my answers will be unsatisfactory, I would have satisfied my objective here, is to make them as unsatisfactory as possible in order to show you that I'm a cross-examiner, I'm not a witness. But let me try. The first 3 interlocutors didn't give me their names, so I'll just call them number 1, number 2, and number 3. Advocates do not represent the morals of their clients. Taking into account the recent case where I was acting for the then deputy president, it was not the then former deputy president, it remained the deputy president. Should the allegations be confirmed to be true, what does that mean to my credibility? Now, as an advocate, I have a duty in ethics to take instructions from my client and not to countermand my client's instructions. I don't ethically have any latitude to countermand my client's instructions. The story is my client's story. And therefore, the story that I narrate is my client's story, unless the story is too ridiculous that no sensible human being can entertain it within the realm of ordinary human interactions and ordinary human possibilities. But so long as the narrative that my client gives me is possible, can be expected in ordinary human interactions and ordinary human possibilities, then I can't countermand it. Let me give you an example. If the client tells me, for example, that on that day the sun rose from the west and set in the east, that's the only story I'm not allowed to carry, because I'm not there as a fool. I'm there as an intelligent human being with my own brain. But if this client tells me I did not steal, I did not engage in acts of corruption, I do not own this property, I do not insult women, I am not disrespectful of women. It's not for me to tell him, no, but the way you look like somebody who steals. The way you look like somebody who insults women. No, I have a duty in ethics of law not to countermand my client's instructions. I'm clear at that point. And therefore, I advance my client's narrative, and that's why at all times, I am an agent of a disclosed principle. My principle is my client. I trust all of you who sit here and know that when you saw me in the Senate, you are all aware I was representing the then deputy president of the Republic of Kenya. A disclosed principle. I can't come here and say I have a client whose name I'll not tell you, but his story is this. That's not how legal practice works. In legal practice, you begin by narrating your agency, telling us who you are here representing. If the allegations are confirmed to be true, it just confirms that my client was wrong in their instructions to me. It has nothing to do with me. I have a duty in ethics not to win at all costs. One of the greatest independences of a lawyer, if you remember latitude, is that a lawyer is independent from winning at all costs. So as a lawyer, you narrate your story the best way you can, as truthfully as you can, as candidly as you can, then you allow the fact finder to make a finding. Otherwise, if it were that every time one party wins, then it means the advocate for the other party is not credible, then every day lawyers will be not credible because one party must win and another party must lose in every case. So lawyers, so long as they act within the ethics of this profession, they are good to go. The second student sought to know the two types of examination. No, there's only one type of cross-examination, and it's called cross-examination. What varies are the types of questions asked in cross-examination. In cross-examination, you can ask leading questions. In cross-examination, you can ask non-leading questions. They are permissible. It is encouraged to ask leading questions because you are dealing with an adversary, and if you allow an adversary to control the narrative, you do not know where it's going to take you. So you lose control. One of the methods of retaining control in cross-examination is by asking leading questions. What are leading questions? Leading questions are questions that suggest the answer to the witness. You make a suggestion of the answer. Then the witness either confirms or denies the suggestion that you have made. There is a tool in cross-examination which you must all take home. Never ask a question whose answer you don't know. By the time you are asking any question in cross-examination, you know the answer to that question, which is why you can keep a witness there 5-6 minutes asking the same, because you know the answer. And using the tools I have alluded to and which I'll continue alluding to in the course of this interaction, you will eventually get that answer directly or indirectly. So I'll give you an example of something that has been trending on your social media handles. And by the way, let me clarify this because I have the benefit of your audience. A bulk of the social media handles you saw in my name are fake. I don't own them. Number one, I didn't make one comment on the case I was handling at the Senate and in court. Because as a lawyer, I know my ethical responsibilities. I cannot be litigating before a judicial or quasi-judicial forum and also in public. That borders on lack of ethics. So there is no single comment from me on this case from the time I set foot in the National Assembly on 8th of October, 2024 to date. I've not made any comment in social media or also on this case. So all those social media handles you have seen under my name or with my photograph making comments on this case are not mine. They are fake. When you come across them, tell the owners that this is fake. My social media handles are only 2, and they bear my 3 names with no appellations of advocate or counsel or Mr. or professor or teacher or whoever. They only have my 3 names. Preparing a witness is a mandatory duty of an advocate. Coaching a witness is an ethical conduct on the part of an advocate. So you must draw the line which is as wide as the Pacific Ocean between preparing a witness and coaching a witness. Unlike we lawyers who practice in courts every day, witnesses don't necessarily appear before courts every day. So witnesses will need to know what is expected of them in court. You'll tell a witness, you'll be put in a box called a witness stand. That's not coaching the witness. That's enabling the witness to understand the environment that they're going to be in. You will be sworn. To be sworn, you will be asked what your faith is. And you must give a correct faith. Either you are Christian, you are Muslim, you are Hindu, or you don't belong to any faith. Once you give that answer, the court or the tribunal knows how to handle you. You will be asked questions. So that is preparing the witness to know what to expect, isn't it? Do not begin taking the witness through. When you ask this question, don't answer it like this. give this, is the witness who is the owner of the story. And in preparing the witness, it is advisable that you put the same questions to the witness yourself, so that the witness gives you the answer. Possibly get from the witness, you told me at point A, your answer was this. Now you are telling me this. These answers look inconsistent. How do you reconcile that? He says, oh, you didn't get me clearly. At this point in time, I was narrating about this episode. At this point in time, I'm narrating about it. Say yes, ensure that comes out clearly so that the fact finder knows that this is this context and this is this context. That is not coaching the witness. That is preparing the witness, because all these answers eventually are coming from the witness. Coaching the witness entails you now giving your own version of the story to the witness and telling the witness, this is the version you are going to narrate. That is unethical. So preparing a witness is along those lines. Ensure the witness understands the environment, how the court works. Ensure the witness narrates their story to you, so that any points that appear inconsistent, you draw their attention to it, and they're therefore able to contextualize better that story. That is preparation of the witness. Ruth, the spirit that does not admit despair is a mandatory component of your work as a trial lawyer. And by the way, the things that will make you despair in the trial process are very many. First, you appear before courts or judges or magistrates who are outrightly disinterested in your case. They are too tired. They have been hearing many other cases. You have been preparing for this case like your life depends on it. Then you find a judge who is completely disinterested. That may give you some reason to despair. You appear before a judge who you know has either been intimidated by forces beyond your control, or has been bribed, or has other extraneous considerations in the case. That gives you a reason to despair, isn't it? I am saying, in spite of all those reasons, you have no reason to despair. After all, doctors treat stage 4 cancer patients who we all know have only one exit route, which is death. But they don't despair. They put their best sense of palliative care to that patient to give that patient a dignified exit from the world. So even you can also give your patient, your client, a dignified exit from the seat of justice. So you don't despair. You put your best tools, your best training, your best logic, your best, skill and judgment to your client's disposal, so the client has a dignified exit. Advocacy before international courts, before regional courts, before local courts, they are completely different ball games altogether. And their differences lies in two things. Number one, in their rules of court. So if you go to the International Court of Justice, it has its rules of that court. You must internalize those rules of court. You go to the East African Court of Justice, it has its own rules of court that are different from the rules of the International Court of Justice. So you comply with those rules. You go to our local courts here, from the Supreme Court to the Court of Appeal, they have their own rules of court. Even locally here, the rules of court of the Supreme Court are different from the rules of court of the Court of Appeal. They are also different from the rules of court of the High Court and the Magistrates Court. It means even when you are doing your work locally, you must also understand the rules of the various courts, because those rules define the advocacy in those courts. So you must comply with them. Over and above the rules of court, we also have the traditions and practices of that court. You must also internalize the traditions of that court and the practices of that court. I know for a fact that because judges of the International Court of Justice enjoy diplomatic status, we address them as diplomats. So you end up addressing them as Your Excellencies. Judges of our Supreme Court do not enjoy diplomatic status. So do not think that you will come before our Supreme Court judges, and because you want to appear pleasant before them, you want to call them Your Excellencies. so that you make them look like judges of the National Court of Justice. No, we call ICJ judges Your Excellency because they enjoy diplomatic status. Because we call presidents, we call ambassadors their excellencies, which is a term in diplomatic circles. When you come to our court here, you have exited those diplomatic circles, you are before a different court. And I'm saying, if you study carefully each of these courts, it has its own traditions. So when you are appearing before any of these courts for the first time, it's advisable that you sit down with somebody who has appeared before those courts prior and ask, what are those core practical steps, practical traditions, practical conventions that I should not lose touch of? So that I'm addressing those courts, I look like somebody who understands their tradition, and those things define the advocacy before those courts. Over and above that, there are things that are of common usage to all these courts. For example, common courtesy is applicable across all justice systems, across all justice traditions. Etiquette, the way we dress as lawyers, the way we address as lawyers. So you talk about dress and address. These are things that we must remember all the time. There are courts that require that you must robe. There are courts that have their specific robes. There are courts that tell you you come with the robes of your national jurisdiction. So you must understand those traditions so that you comply with those traditions. What I tell lawyers is this: if you go before a court and you don't comply with the traditions and the rules of that court or the etiquette of that court, the judges will take it on you. And they want you to explain yourself on why you're not complying. And the danger with that is you end up having to argue your own case first before you argue a client's case. You don't have the time for that. Psychologically, you get beaten by the time you have finished arguing your case. So you begin arguing your client's case like a man on crutches. In a race, in a proper race, if you're going to sprint and you are on crutches, you can't win that race, isn't it? Unless you are in Paralympics where everybody's on crutches, isn't it? So that's the point I'm trying to make. That if you go into normal summer Olympics and people are going to sprint, prepare yourself for the sprint. Don't walk in with the crutches because you may not find favor with the other participants in that case. So that answers Ruth Jebet's case. Karen, how do you prioritize which questions to ask? Trial process is an art. The trial process is an art. And it depends on what objective you want to achieve out of your art. When you go to a football contest, different coaches have different approaches in the sport. There's a coach who will advise you to hold the ball, to keep the ball in your circle and hold it until the other team becomes tired. Then you begin advancing into their half, isn't it? There are those who will tell you, we want to score fast. We want to make fast. This team takes time to settle. So you want to make the first few scores fast. But by the time they settle, you have 3 scores in your favor. So you see a team begin the sport and they are pushing into the adversary's half immediately because they have been told, this team takes time to settle. So take advantage of that to score the first 3 balls, then you can now hold. Trial advocacy works the same way. So I go to court and I know this witness has spoken some manifest lies here. Plain lies. I mean, they're not borderline lies. I go in saying, I want to start with those lies first. So that this witness becomes so destabilized that when I come into partial truths and move into actual truths, he's so unstable that he looks completely not creditworthy. That's my approach to this witness. So that will determine how I start. I would start with those things that the witness is completely can't defend. They are morally indefensible and intellectually unsound. So that's how I'll prioritize my questions. So it depends on the objective you want to get out of every individual witness. You will see what to do. When you are cross-examining, for example, an expert witness, do not prioritize questions that appear to question science itself. Because science is a general experience of mankind. And the judge or the fact finder is more likely to believe what science says than what your hypothesis as a lawyer is saying to question science itself. So you begin by questions that confirm science. Then, if you believe this witness, for example, has given opinions that are inconsistent with science, then you take him there to sway the fact finder to your side. Common mistakes that advocates make and how to avoid them. My foremost mentor, I'm sure many of you now know, Professor Gitu Muigai held my professional hand from the time I was 23 years old. And I have a lot of respect for him because I've always wondered what the trajectory been had I not met Gitu Muigai as my lecturer at the university and as my pupil master in pupillage. I don't know. And because history is such that you cannot replay history completely with new environment to see how it would have turned, we only live with fear and anxiety on what life would have been had the environment not conspired the way it conspired to lead you to where you end up being. But Professor Gitu Muigai told me that when you are cross-examining, you are not a supplemental prosecutor. A supplemental prosecutor is one who, in the first 5 minutes, is asking, so you said this paper was white? Yes, I said the paper was white. So you said your name was Ongoya? Yes, I said my name was Ongoya. So you said you teach at Kabarak University School of Law? Yes, I said. So you are wondering, where are these questions leading us to? These things, the witness said them already and we know them. Go to where you want us to go. Some lawyers do that. They have no idea where they want to go. The second category of mistakes are lawyers who ask questions whose answer they don't know themselves. They have shot in the dark, hoping that the bullet will catch some thief, somebody in that dark. By the way, that bullet will hit the wall and boomerang and hit you. When it hits you, you will be injured or dead. You'll not ask a follow-up question. The third mistake I know is lawyers who don't know when to stop. Who don't know when to stop. There's a way you push the witness to a very favorable answer, and you push just one more step, and the witness gives another answer that destroys all the grounds that you had covered. They don't know when to stop. So knowledge of when to stop is crucial. Then finally, a final weakness is lawyers who ask open-ended questions. Questions that give the witness a field day to explain themselves from, the southernmost part of Africa to the Sahara. That way, you submit yourself to the guidance of the witness, as opposed to the witness submitting themselves to your guidance, and your cross-examination does not achieve any purpose. Bernice, what does a great cross-examination look like? I honestly do not say I know what a great cross-examination looks like, but I know a hopeless one. So I trust that a great cross-examination is one that avoids the pitfalls of a hopeless cross-examination. And the pitfalls of a hopeless cross-examination are the ones that I have given in response to Karen's question. As much as possible, avoid open-ended questions as much as you can. Ask close-ended questions. Ask leading questions. As much as possible, ask questions whose answers you know. Don't ask questions whose answers you don't know. As much as possible, don't ask compound questions. Seek one fact per question. As much as possible, know when to stop, including not asking any question at all. In fact, the most terrifying moment in cross-examination is when a lawyer stands up and says, I have no questions in cross-examination. Sometimes that is the most powerful cross-examination. It may mean that this witness has so destroyed himself in the evidence in chief, and yet by cross-examining the witness, You'll give the party calling that witness an opportunity to re-examine and possibly correct part of the harm caused in the exam in chief. So that is it, Bernice, in answer to your two questions. The second last question was the common mistakes and how to avoid them. I trust I dealt with that when I was dealing with Karen's question. So I would loop the answers that I gave Karen in answer to that. Finally, preparation. Allow me to take some 2 minutes to address the subject of preparation generally. If you are going for any artistic contest, whether you are going for a poetry competition, whether you are going for a choir competition, whether you are going for a football championship, whether you are going for a rugby championship, whether you are going for a beauty contest, you all engage in preparation. So preparation is critical for all artistic contests. And so is the preparation for trial. You must prepare. And preparation is there from the very beginning. From the time the client walks into your chamber or calls you into their office, you begin preparation there by internalizing your client's story, by reading your adversary's story and understanding it fully, by doing what we call in trial preparation a case analysis. A case analysis means you prepare your chart. You prepare for your case the way you do classes here in the lecture halls. You prepare a chart on a whiteboard. On that whiteboard, you would have 3 columns. The first column is, what are my good facts? What are the strengths of my case? The second column is, what are my bad facts? What are the congenital weaknesses of my case? A case comes to you the way it comes. It has some weaknesses it was born with. You don't avoid them, you document them. The third column is, how will I mitigate my bad facts? So at the trial, you'll be amplifying your good facts. You'll be trying to dim your bad facts by use of the mitigations that you have identified for your bad facts. That's the preparation. And therefore, when you are doing cross-examination, you're trying to bring out your good facts as a gong in the darkness, as loudly as possible, trying to mitigate your bad facts by using very many tools. One of the tools is just by anticipating them, by admitting them. Saying, I know we made this mistake. You know, once you tell a fact finder, I know we made this mistake, your adversary can't ask that question, because what new is he bringing forth? You have already removed the oomph from their case. And like when you try to cover it, then your adversary brings it out. You look so bad. You try to cover your face. You begin prevaricating on your chair, hoping that he will stop soon. When we were doing the cross-examination at the Senate, I received a lot of messages on my WhatsApp from one of our adversary's lawyers telling me, please, Ongoya, now stop there. I think you have already harmed us enough. And he's a friend, so he was saying that in jest, but he actually texted, he's saying, now there's time to stop. You know, you're now going against the rules of engagement. The rules of war are that once your enemy is down, you must stop. You know, those of you who have done international humanitarian law know the rules of war, isn't it? Yeah. So he told me long after we were having lunch that I violated all known rules of war. I pleaded guilty. So I'm waiting for mitigation at our next lunch by buying him lunch. But preparation is crucial. Write down your areas of cross-examination. Write them out. I will cross-examine on this theme. And on that theme, I will bring out the following issues: number 1, number 2, number 3. And tick those themes as you finish them one by one until you finish your entire case and you have ticked every theme. There is nothing more harmful, more debilitating, more robbing of your self-esteem as a lawyer than to leave your cross-examination podium, then say, oh my God, Guy Fafa, I forgot this one. It robs you of your self-esteem completely. But if you had written down your questions properly and you are ticking them one by one as you proceed, you leave knowing that I may not have done a perfect job, but all I could have done is all that I did. And that way, you retain your self-esteem throughout. I trust I have dealt with all the sets of questions that were asked. I'll come back to the moderators to get me the next set of questions.
So, yes. So I'll ask one question, then again, we'll pick a round from the audience and from the online audience. So my question is, courtrooms in Kenya often have limited time for each session.
Yes.
How do you ensure that your cross-examination is concise yet effective under these time constraints?
Thank you so much. Our courtrooms have time constraints, and not just courtrooms in Kenya, courts the world over now manage time because it's understood that justice is also a function of time. So because of that, you begin to understand why in your qualifications to study law, you see a statutory qualification that you must have a B in either English or Kiswahili. Because in English, you study something called summary. And you passed examinations in summary as a precondition for your admission to law school. So you can't lose your skill in summary as a graduate of law school. That means you simulate scenarios. You ask, what do we do if we are given only 15 minutes? You say, we will ask the court to give us slightly more time. And you see lawyers saying, my lord, 15 minutes is too short, kindly give us 30 minutes. So what if the court sticks its ground and says, I'm not adding you time? You say, if I am given 15 minutes, the areas I have underlined in red are the only ones I'm going to deal with. What if I am given 30 minutes? If I'm given 30 minutes, the areas I've underlined in red and green are the ones I'm going to deal with. What if I am given 1 hour? If I'm given 1 hour, the area I've underlined in red, in green, and in black, and in blue are the ones I'm going to deal with. What if I'm given 2 hours? If I'm given 2 hours, I will deal with all the areas on my notebook and areas I have not put in my notebook. That's a preparation tool. So that's part of preparation. So you have already mapped out your case, and you have known that the areas I've underlined in red are the irreducible minimums. Finishing my case without dealing with any of them is a death knell for my case. The other areas are various icings on the cake. So I can deal with the first level of icing. I can deal with the second level of icing and probably add some fruits on it. I can also embellish my cake by covering it properly, but I can do without covering my cake, isn't it? So I can remove that if time is a limitation. The cake will remain a cake without the icing. So I can remove the first layer of icing if time is a limitation. So I'm using all these allegories and anecdotes just to let you know that part of preparation, part of planning is simulating how you deal with different scenarios depending on how much time the court will give you. Now, some courts will give you the time schedules in advance. Like when you go to the Supreme Court, you get the time schedule in advance. It's written to you when you get the notice to appear. It comes with a schedule. That schedule tells you your time. So you already know your time, and you prepare with that time. Of course, saying we'll try to ask for more time and see whether I will be given. But if they stick to this, you already know what you are going to deal with. So that's how we deal with that time question.
Yes, now we can have a round from the audience.
To our audience, in the interest of time, I'll request everyone who has a question to please rise up so that it's easy to pass the mic. We have some 43 questions on Zoom already, so we need to save time as much as possible. So anyone who has a question, please, in the next 1 to 3 minutes. Please be upstanding, then the mic will be passed to you.
Good afternoon, everyone.
Good afternoon.
Aside from what you have said that you do not take cases that are prima facie ridiculous, are there other considerations you put in before taking a client's case?
Good afternoon. My name is Jimmy Wambua, and my question is on cross-examination. What are the probable strategies that you can employ in examining a witness that is somehow non-responsive due to language barriers or an issue of literacy levels?
Okay.
Good afternoon, everyone.
Good afternoon.
So my question is this. Obviously, humans are emotional beings, but what is your take on cross-examiners who directly ask lines of question to provoke certain emotions in people? Do you think it's ethical, or do you think it's like wrong? Yeah, thank you.
Okay.
Good evening.
Good evening.
My name is Maurice Henry, fourth year law student. I watched you in the case, Kawira Mwangaza's case. I watched you in the former deputy president case. And my question will be, you have said that cross-examination is an art in itself. So the question is, to make this art, it has to be memorable. And after seeing you as a guru in the area, I've seen you vary your tones. I've also seen you being very poetic. For example, when you said to this witness in Kawira Mwangaza's case, you have elevated jokes to literary levels. So how do you maintain seriousness, tone variation, and poetry in the case so that it remains your case remains memorable in its entirety?
Okay.
Thank you.
Considerations before taking a client's case are defined, or they ought to be defined by the ethics of our profession and no extrinsic considerations. One of my foremost mentors, whom I hope will get a chance to talk to you before it is too late, is a man called Feroz Norovji. Feroz Norovji is one of the most prolific courtroom lawyers this country has ever witnessed in its pre- and post-independence history. And Feroz Norovji has argued in very many matters across all courts in this country and has retained a significant ethical presence, ethical standing in our profession. The most important rule of ethics in this profession is the Kabarak rule. And perhaps with this, with your generation and its online apps for taxi services, you may not understand what you mean by the Kabarak rule. The Kabarak rule is a rule that was derived from the cab ranks in London many years ago. A rank is a place in a city where taxis park. That place is called the taxi rank. It's a place where the taxis park. And in where taxis park is that you go to the taxis are on a queue. And you know the next taxi, that is, they'll take the next customer. That taxi must take the next customer. Once I arrive as the next customer, it cannot say, no, you don't look very good. You'll be taken by that. Me, I'm waiting for more premium customers. You take the next customer. So our rule of ethics is that you should never turn down a customer. Every client who comes to you must take them unless you are prohibited by a rule of ethics. Primarily among them is conflict of interests. So if there are conflict of interests, then you can now turn down for the client to go to the next advocate. But in the absence of conflict of interest, you have actually an ethical obligation to take on that customer. And a second element is now, this is a more business element, is your own perceived expertise in that area. Lawyers now tend towards specialization. And if a client comes to you and you think that it's not an area you think you are very good at, you may then end up doing disservice to the advocate, to the client, by taking up that brief, in which case then you'll tell the client, no, this is not an area I am very adept at. move to the next person who is more adept at that. Those are the only justifiable considerations. Barring those considerations, fellows, none of you taught me that the office of an advocate is a constitutional office, which is why advocates are mentioned expressly in the Constitution in Article 50. And I believe him because the number of years he has put in this profession is he can't lie to me. Jimmy, the question you raise is germane. There are a number of challenges we lawyers face in real courts. And Professor Gedu Muigai taught me this in an old case. I know it was a murder case. I just remember the name of the deceased in that case, a man called Kamaldeen Akasha, who had been shot dead somewhere in Mombasa. And Professor Gedu Muigai was retained to defend one of the accused persons in that matter. And a lot of witnesses came from Mombasa, and you know that people from Mombasa are more comfortable speaking Kiswahili than English. This trial was happening in Nairobi, and the prosecutor insisted on English, and therefore getting a translator to translate for him. And you know, in our court system, we don't have proper translators, language translators. What we have are court clerks who then attempt translation. Now, translation is a whole area of learning. So if you have court clerks doing translation, a lot is lost in translation. Professor Gedu Muigai, in cross-examining each of these witnesses, cross-examined them in Kiswahili. And therefore, he had a better rapport with the witnesses than the prosecutor who had brought those witnesses in court. So that's one of the tools that you use, that if you are adept at the witnesses' language, then you better step back and use the witnesses' language, because you are communicating better than using your own language of preference, subjecting yourself to a translator who is not very good at translation. Then the question reaching the witness, some meaning has been lost. Then the answer coming to you, some meaning has been lost. By the time you finish that cross-examination, you have been tortured yourself. So that is one of the things we deal with. I remember one day I was doing a trial here in Nakuru many years ago, and the witness was a Kikuyu in terms of ethno-linguistic origins. And he insisted on talking in Kikuyu, a language I know very little or nothing about. But I was briefed that this witness, who is insisting on speaking Kikuyu, had served as an engineer at Nairobi City County, then Nairobi City Council. Surely, an engineer can speak English or Kiswahili. So I had to remind the court that whereas a witness is entitled to a language of comfort, the official language of the court remains English. And therefore, the witness must have a justification for departing from the official language of the court. This witness, who is an engineer, has no justification for departing. And the court agreed with me and compelled the witness to speak in English. And that made my work more palatable, because we were able to communicate in my language of primacy of understanding with the witness, which was English. So these are tools that we go through. Otherwise, if you go through witnesses who suffer disabilities, for example, and therefore can only use sign language, you have no recourse but to humble yourself. It just means you must speak slower. You must listen more attentively to what the translator is saying. You must seek more clarifications before you move to the next question. And that takes a little more of your time. A court properly applying its mind will give you more time, because they can see the difficulties you are working under as you deal with the witness, which are not difficulties of your creation. Courts are human beings. And courts know when you are properly exercising your tools of cross-examination and when you are simply humiliating a person. Please never attempt to humiliate a person. There's a case I don't like talking about. The Senate case is not a case I am good talking about because I was involved in it. And to talk properly about it, I must begin by conceding my own weaknesses first, person's weaknesses. I don't like talking about it. Many of you will remember that the witness I dealt with, I began by confirming he is a lawyer like me first, before I did anything to him. And you remember that was the very first question. It's because you first, before you dig in. Otherwise, if I was dealing with an illiterate older woman from a Esrabe village in Vihiga County, where I was born and raised, and you are too tough on them, you begin looking like a bad man. You don't look like a cross-examining counsel. So you begin by, first of all, elevating this witness first, the level of a lawyer. And if you look at many of the social media attacks my witness received, they were based on the fact that, is he a lawyer? That's what they were based on. But had he come out as a village, less exposed, less endowed economically, poor Kenyan, then you must be careful how you approach that cross-examination. Otherwise, you're going to lose favor with the fact finder and the public. I'm just answering Jimmy's question about when you're dealing with witnesses of low literacy levels, low educational levels, low economic levels. I was dealing with a powerful person, a state office holder, member of parliament, lawyer by training. This is somebody who admits no sympathies. So once you set out that basis, you therefore allow yourself some latitude of abrasiveness without offending the fact finder. Allow me to repeat this. It is very easy to offend a fact finder, the judge or the magistrate, through cross-examination. I'll give you a few examples. And this will also deal with the second last question about emotional questions, emotional issues. If you are going to cross-examine a child victim of defilement, you must come across as humbler than that child for your cross-examination to have effect. The court is a human being. The court's sympathies are already with this child, humanly speaking. The court is no longer just sitting as an impartial, dispassionate fact finder. No. The court's sympathies are already with this child. So your cross-examination, even the way you put your questions, you must look like you're apologetic for even asking that question. That way, you retain the presence of the court. Otherwise, if you deal with a child victim of defilement, as if you are dealing with Mr. Mutuse, my friend, you have lost emotional intelligence and you have lost completely. So you must be a judge of the situation. That's the question I'm putting across in answering Jimmy and the lady who asked about the emotions of the case. You must be a judge of the situation. You must be emotionally intelligent. In my career as an advocate, I have cross-examined people who serve as prosecutors. I have cross-examined judicial officers. In the olden days, when the rule was introduced that confessions could only be taken before a judicial officer, magistrates used to take confessions and they come to court to produce them. I have cross-examined the magistrates. You must be very careful. Remember, when you are cross-examining a magistrate before another magistrate, always remember this magistrate is before a colleague and you are the outsider in that pack of animals. Have the presence of mind when you put your questions. Don't try to humiliate a magistrate before a colleague. You will fall out of favor with this colleague of theirs. These are professional cousins at that level. Don't lose focus. You are the only outsider in that family. Remember that fact all the time. Not to be intimidated, not to be humiliated, but just to be emotionally intelligent so that you achieve the end you want to achieve without antagonizing the court. I have cross-examined a 5-year-old child, victim of defilement, 5 years of age. You know, I don't know whether you have ever sat with a 5-year-old day to day. By the time you get them to answer your question, just generally, forget about defilement. No, generally, it is not easy. So remember that all the time. And here you are supposed to ask them the most personal of personal questions in defilement. So be careful about how you put these questions. And that's where you learn children and the law. You learn how to be child-friendly. You learn how to make the environment very comfortable for the child. You begin by asking the child questions that enhance their self-worth, how they are performing well in school, how you are proud of them as children, how you know they are cooperative with their parents, how they go to church, how you are very proud of them. By the time you now go into the questions that show that, by the way, the story you have told us here about defilement is not credible, they don't know when they lost it. They have already given you answers. to your question. One thing I like about children is children tend to be very honest. And in many defilement cases, either the child has been actually defiled, in which case also be empathetic to the child, or the child has been coached to lay a trap for somebody, in which case the child will actually cooperate with you and he will actually answer questions to show he has been used as a tool in an abrasive game of somebody who has to get to another. And that you can't achieve that by being abrasive with the children. So that's something you need to be emotionally intelligent about. Never lose your emotional intelligence. Maurice, the next topic perhaps that we should ask Anne to organize for us to talk about is that whole area of learning called the place of humor in the trial process. Whereas the trial process is serious business, there is plenty of space for humor in the trial process. In fact, humor helps in your tools of persuasion. Humor helps in your persuasive capacity because the judge is a human being and the judge is getting emotionally drained by this serious matter of how somebody was, slaughtered literally in a murder trial. How the judge has to look at the postmortem reports. Not just the report comes with photographs of actual cutting of the person's head and stomach to show how the samples were removed. The judge must see all that, and the judge must listen to you. By the time the judge finishes to look at the postmortem expert, he has seen so much. He has seen the person's intestines, the blood, everything. He has seen the head being chopped off by the postmortem pathologist. The judge is already traumatized. There's a place for humor to try and rehumanize the process. So Maurice, I'm telling you that I'm hoping that Anne will organize for us a whole sitting for 2 hours on humor in the trial process, because it's something I'm also trying to learn, and I can share the lessons so far captured in my learning of that area. Humor can cut both ways. You can look like a fool in attempting to be humorous. So choice of moment is important. Oftentimes, the moment announces itself. You don't announce it. So you don't write in your notes, I'll be humorous here. The moment announces itself. The moment presents itself. And sometimes you don't even know you're being humorous. Sometimes it's the audience that actually finds you humorous. That's the best use of humor. I have tried to convince my friend Joseph Omolo Agutu that when I told Honorable Mutuse it's getting hotter, just compose yourself, look at the document and read, I was not intending to be funny at all. I was actually being courteous to him. I was trying to make the environment comfortable for him, because remember, the man was with me at the university at the same time. We were in the university together. Him, I think, in the School of Agriculture and Livestock Development in Upper Kabete, and I at Parklands campus. And so someone I know, he was my student leader. He was an official at SONU, when I think the organizing secretary, when I was an ordinary student in class. So it was not pleasant for me to see him looking harassed, which is why, out of courtesy, I tried to ask him to compose himself. And Mr. Molo does not believe up to now, but with time I'll convince him. And I'm being honest here. I'm not trying to be funny. I'm being honest. So sometimes humor happens like that. Sometimes humor happens like the way Feroz Norovji does it. When Feroz Norovji was arguing the presidential election petition in the year 2017, he tapped onto something called the Bermuda Triangle in the Atlantic Ocean. And he was trying to equate bombers of Kenya to the Bermuda Triangle, that we see returning officers arriving with forms. Then those forms disappear. No one sees them again. The way things disappear at the Bermuda Triangle, and no one knows where they go. And he kept saying, the problem is not that those things disappear. The problem is that no one knows what is happening there. I mean, it creates an element of humor in the trial process. I remember one day, an advocate at the Supreme Court trying to quote the Bible. So he referred to one verse in the Bible, which was okay, then went to another verse, then went to a third verse. Now, That now being funny, because remember, you can quote the Bible, but remember, we are not in a theological forum or college, so you must know when to stop. When we went to the third one, Dr. Smokin Charles Wanjala, my former lecturer at the university, stopped him and told him, before you get to the book of Ecclesiastes, let me now guide you. Now, that moment before you get the book of Ecclesiastes became itself a very humorous moment. We all broke down into laughter. And I'm not sure the judge in his notes had said at some point in time, I will refer to the book of Ecclesiastes. It comes when it comes. When you want to use humor, avoid stereotypical statements. Avoid gender stereotypes, avoid racial stereotypes, avoid ethnic stereotypes. All humor boomerangs back on you when you try out any of those stereotypes. If you told me, you know, I know you are a Luo, but that already kills your humor. You look so bad already. So don't try out those things. But I'm saying there is a place for humor if you deploy it appropriately in small doses and don't overuse it. Because remember, the business that keeps people in court is almost always, actually always, it is serious business. The humor is there to be dispensed in small doses to create some comic relief. Then we make progress. So that's the balance as I will do it. Now, Maurice, I was a bit surprised when the Senate trial process took the nuance that it took, because friends of mine whom I debriefed with, including Professor Osogo Ambani, who has been my client in a traffic trial process here, knows that that is my trial style, whether I'm dealing with a traffic case or an impeachment case or a murder case. And my good friend Luciana Thuo told me a few weeks ago that you are a good person to have on your side. You are a very annoying person to have on the opposite side. It's annoying because there's a way you ask those questions that are intended to irritate. I am sorry to all witnesses if I've ever irritated them. And using this forum, let me announce to them, I have never intended to irritate any human being in my lifetime. So if they have been irritated, that is an unintended consequence of the cross-examination process. Bottom line is, all these things are functions of practice. All these things are functions of trying it out, getting it wrong, retrying again, getting it wrong. All these things are products of many years of trying to invest in general credibility. General credibility. If you are known to be a generally dishonest person, people won't find your cross-examination convincing, even if you take it very seriously. People say, there he comes with his tricks again. But if you are generally credible, people tend to believe you, even on the rare occasions when you slide and you look like you are annoying or you are irritating. I think that answers the 4 questions. I'll now come back to you, Anne, to get the question from our online audience.
Thank you very much. To our amazing audience, allow me to be seated for good order. Thank you once again for your insightful questions and equally insightful answers, Mwalimu. To our audience on Zoom, we continually appreciate you for your presence and engagement. Mwalimu, you'll guide us on how best to go about this.
Can I get 3 questions at a time? Sorry for that interruption. Yes, so I was saying, all of us are human beings, and as human beings, there are moments we are proud, we are happy with what we have encountered, we are ashamed of what we have encountered, we are angry with what we have encountered, and this happens at every stage. So you must always remember that you are a professional. Never forget that fact. Once you remember that you are here as a professional, then a lot of these things will fall into place. Now, however much you remember that, there are moments when we lose it. I have gotten feedback from my performance at the Senate, and there are 3 or 4 moments when I lost it completely. I'm told I shouted at a colleague, which is very bad. It should never happen again. Never try that in your lifetime. Avoid it as much as possible. It's not one of my best moments. I personally called the colleague and apologized to him, and I have lunch on my account. When we meet next, we are scheduling it so that we make up, because we are in the same profession. Tomorrow we'll be on the same side. So we lose those moments sometimes. When you're on the roll, you never know how you manage it. But remember, you have a client to fight for. And remember, you fight for that client best when you are calm, when you are collected, and when you are composed. Remember those facts all the time. Once that remains at the back of your mind, you will remain calm and focused throughout. And I've told you, you already have your themes, your thematic areas of examination and the issues you want to bring out. So that will help you to also know that I've finished this issue. I have 3 more issues to go. So if I lose my composure now, I will not finish the remaining 5 issues, and that will not be in the best interest of my client. Allow me to close by saying, what is in the best interest of your client is not always what is interesting to your client. Sometimes your client wants to see you hammering his adversary more. Sometimes that is not always in his best interest. So you may need to hammer them less, elevate them a little more, then know when to hammer, when it's appropriate to do that. The next question.
So the next 3. Who has been the most influential mentor in your career? What impact did they have on your professional development? Same question. Most significant lesson you've learned in your career and how it has shaped your approach to trial advocacy.
Repeat that question.
Most significant lesson you have learned in your career and how it has shaped your approach to trial advocacy. And then the next is, could you guide us on how to properly conduct cross-examination in virtual proceedings, owing to the fact that the witness is not present and therefore you cannot study and analyze his or her demeanor? And lastly, concerning the latest case where the first counsel of the DP, what made him not win the case?
Okay. Let me start with the last question. What made me not win the case? The case is still in court. So the jury is still out there. We will know what made me not win the case at the tail end. Perhaps when the Supreme Court pronounces itself on the matter, we don't know how many years to come. But what is sure is that we lost the case, and humility demands that we admit that we lost the case and introspect and ask, what can we do better? What can we do differently? But more importantly, we lost the case because we are human beings, and human beings win and lose every day in their lives. That was our day to lose. We take it in stride. We pick the lessons learned from it, and we become better people tomorrow. And very lastly, more importantly, it's not the first time I'm losing. So I lost the case because I've lost before. The most influential mentors in my life, there are 3 human beings who I keep wondering if fate had not conspired to make me meet them, what my professional life would have been. One is Professor Githu Muigai. 2 is Mr. Mohamed Jairus Nyaoga, the immediate former chairman of Central Bank of Kenya. He was a partner at Mohamed Muigai Advocacy when I joined that firm. 3 is the late Justice David Amilcar Shikomera Majanja. Fantastic human beings. Fantastic human beings. Human beings whom I'll commend to all of you. I don't know how you're going to meet Majanja without dying first. But in your life, if you can manage to meet them, I would encourage you to meet them. There are other people like Feroz Norovji who remain very impactful in my life long after their retirement. I still endeavor to meet them once in a while just to tap into their wisdom. There are people who may not know, people like Mr. Ungicho, people who taught me research skills. So there are a number of people who have played an enduring role in my life, and they continue to play an enduring role in my life. And I don't know what life would have been if I had not met those people at the point when I met them. I thank God that I met those people at a more malleable phase in my life, when I was younger, at your age, in my 20s, when I'm still willing to learn more, when I am more flexible to new learning, when I'm more respectful of people. And they were therefore able to impact me significantly. And I would suggest that you identify mentors early in life and submit yourself fully to being mentored. I repeat, I urge you to identify mentors early and submit yourself. Submission means, you know, the way we go to church and we don't question God. Yes, get to almost that point. Submit yourself fully to being mentored. Later in life, you'll begin discarding some of the things they told you, but at an early age, submit yourself fully to being mentored. You'll benefit more than you'll be harmed in the process. Of course, you'll suffer some harm. When you submit fully to somebody, there's some collateral harm you suffer, You will discard that harm as you get along, but the benefits will far outweigh the harm. Most significant lessons learned in my career is that at an early age, that I submitted myself to mentorship early is something I have never regretted. People like Professor Gidu Muigai had some mentorship strength that I pray to God I get even just a half of it. I'll be happy. They empowered us. They liberated us to experiment with the cases that they gave on our desks, to do research, prepare submissions, prepare pleadings. They released us to court without us looking over our shoulders. We had to do the best we could do with the cases they gave us. Those things enabled us to become better versions of ourselves. Some clients lost in the process. I look back at some clients who lost because of our inaptitudes at early ages, and I wish there was a way I could refund them or I could pay them back, but there's no way. I guess the same way some of us lose lives in the hands of doctors so that they become better doctors later in life. But the advantage of doctors is they bury their mistakes. Lawyers live with their mistakes throughout their lifetime. And therefore, I look back at some of those cases and I wonder, I wish I was doing that case now. But it's the nature of this life. And therefore, to all clients online who are following us, sorry. That happens a lot. It's an integral part of what we have become and what we are becoming. We still make mistakes today. And I guess we'll make mistakes by the time we die because none of us can become perfect versions of ourselves. We are all work in progress across the path of our lives. So let me deal with the final questions. How to properly conduct cross-examinations in virtual courts. Virtual courts remain a challenge to many of us, I included, because majority of us are what we call digital immigrants. We are trying to migrate onto the digital platform. And many of you who are students in this hall and many students online are digital natives. You are born in this world of technology, and therefore you're going to manage technology better than many of us have ever done. We are therefore poorer teachers to you on how to manage virtual platforms. But what we do is just to try and apply the same tools with necessary modifications. For example, we insist that people have their videos on. That way, we are able to see them. Number two, the same tool, so we ask questions in a slow incremental manner. We ask questions, confirm that the person at the other end has heard us because of network issues, then get the answer. It takes a lot more time. And I guess we'll just remain in this experiment until technology itself becomes more reliable. For example, when we just drop off a virtual platform, it's something you have no control over. You are in court and you discover the court can't hear you. We were in the Court of Appeal this morning, and I think, Annie, you were there with us, and you noticed the court couldn't hear senior counsel Paul Mwite for a long time. It happens. What do you do about it? It's happening. So just live with it, and we become more courteous. The court becomes more courteous. It gives you a little more time until it can hear you. You become more courteous. You apologize for the problems of technology. You can imagine. You are apologizing for the problem of Safaricom or any other service provider, but you apologize. That's how we deal with it. Then we try, when the technology is good, we put more questions. When the witness can't hear us, we become more patient with the witnesses themselves because they are also just persons. And witnesses sometimes behave like students. When you ask students in class a question on a virtual platform, all of a sudden their gadget becomes problematic. They say, my gadget had a problem. So you realize as a teacher that if you get angry with them, you'll get depressed. So you remain at peace with them and you accommodate their gadget problems until you discover that as many learners have gadget problems as there are complex questions. In the beginning, making your questions simpler. But all these are things that is work in progress. So we are trying to learn them. We can never possibly get the best out of the virtual platform as it stands today in the trial process. We got better out of physical courts in the trial process. But I'm hoping that technology will become better. Lawyers will have better cameras in their trial boardrooms, and therefore will be able to see a three-dimensional view of the boardroom. technology will become stabler as we get along, and therefore there will be lesser technology hanging, and lawyers will become economically richer. They will invest in better offices than the ones we see when we see them online. And over time, the new normal will give us an environment that is as close as possible to a physical court. But as things stand today, we are getting a raw deal from trials on a virtual court than we got in trials in a physical court. In fact, some conversations have it that virtual courts are killing the art of advocacy. I think I can take more questions.
The next three. One, a question on the rules on cross-examination, especially the approach used by Ndegwa in examining the doctor. Should an advocate use a document that a witness didn't swear or file as an affidavit to cross-examine a witness, or was that a dark art approach? Two, former Deputy President Rigathi Gachagua withdraws an appeal he had lodged at the Court of Appeal seeking to stay High Court proceedings in his impeachment. What are the implications of this? And lastly, now a set of three, when should you not cross-examine?
Allow me to, first, I don't want to comment on any other advocate and their performance because it's not ethically right to do that. It makes no sense. So I'll not comment on any performance, good, average, or otherwise of any colleague across both sides of the recent impeachment process. It is a complete lack of professional humility to begin talking about other professionals to students. It doesn't sound right. But having said that, I would answer the general question of use of a document not authored by a witness to cross-examine a witness. There is no limit to the scope of questions or reference material an advocate can refer to in cross-examination. The only limitation is on relevance. So the only time the court will stop you is if you begin cross-examining somebody on irrelevant material, by which it means they have no bearing on the fact in issue. But so long as material has a bearing on the fact in issue, you can cross-examine on. Particularly where all that you want is to show this witness that what he or she is saying is at variance with what other witnesses have said. That will serve two purposes. One, the witness will get to know that he's giving a story that is at variance with the story of other witnesses. But two, and more importantly, the fact finder, the judge, the magistrate, the tribunal will know that the story this witness is saying is inconsistent with stories that other witnesses on the same side as him or her are saying. That's what you want the fact finder to keep at the back of their mind. So that is the objective that this serves, and therefore it's not an illegitimate tool. However, there's only so far you can go with it because this witness will continue disowning the other story. So apart from getting this fact, you must know when to stop, whether you don't look like you are badgering the witness. Former Deputy President withdraws appeal. First, let me fact check the question. The former DP has not withdrawn any appeal. What the former DP has done is to withdraw an application that was seeking to stay proceedings because what was sought to be stayed ended on Thursday last week. So since it has ended, that application for stay of proceedings was overtaken by events. Otherwise, the appeal remains on record, and the court today directed that it must be heard and determined before the end of the term of this term of the court, meaning before 21st of December of next month. That's next month. So that appeal remains on record, and therefore that has no bearing, if you asked me, on the case strategy. That appeal questions a very limited question, whether a Deputy Chief Justice can empanel a bench under Article 165, Clause 4 of the Constitution generally or without express permission of the Chief Justice, or whichever way the issues will come out at the trial. When should you not cross-examine? Number one is when you have no information you want to extract from that witness in cross-examination. A witness can be so truthful in what they have said that cross-examining him will only make you look bad as the cross-examiner. You do not cross-examine. A witness can say things that are so irrelevant to the case, so irrelevant that cross-examining them will not make them any more irrelevant. They are already too irrelevant. A witness can say things that are so damaging of their own case, so damaging that you can't damage it any further by cross-examination. You don't cross-examine. A witness can have testified, and the person who was leading that witness in chief avoided something that would have demolished your case so badly. If you cross-examine, you give them room for re-examination and possibly correct. It is advisable in your client's best interest. You do not make matters worse for your client. But remember, they have a right to recall their witness if they want to and put that evidence on record. You may then consider cross-examining at that stage if they recall the witness. So all these are different factors that may make you conclude that you have no questions in cross-examination of a witness. A good example is where a case has, say a criminal case, has about 4 accused persons. And each of these accused persons has their own advocate. So you act for accused 1. A witness comes and gives evidence that touches on only accused 4. It doesn't touch your client at all. For you, it will be advisable not to cross-examine, leave the burden to the advocate for accused 4 to carry his load. Otherwise, you may think you are cross-examining in favor of accused 4, and you ask questions that are inconsistent with the strategy of the advocate for accused 4 and his client. So rather than damaging other people's case strategy, focus on your case. And if the evidence didn't touch your client, keep off that evidence. Back to you, Anne, for more questions.
Thank you, Mwalimu. And once again, thank you to our audience, especially for giving me discretion to pick the questions that you're posing to Mwalimu. Interest of time, and also because some of the questions already been answered either directly or indirectly, but I believe there's an answer out there already. The next set of 3. 1, what is the place of the judge or impartial umpire? I hope I got that right. In cross-examination in lieu of the audience. Next, what should one consider when cross-examining an expert witness? And lastly, in Kenyan court, how do you effectively manage objections from opposing counsel during cross-examination to maintain control of your narrative without disrupting courtroom decorum?
Okay. Thank you so much. The place of the judge has a moral, ethical, professional, and I would say constitutional and statutory obligation to remain impartial throughout the process. That's number 1. Number 2, the judge must also, in maintaining that impartiality, remember that we are in an adversarial legal system where the adversaries are the 2 parties, and the judge, even symbolically, has their seat elevated so that their eyes are not distracted by the disputant, the dust that arises out of the disputant's wrestling exercise. But the judge is not a fool, and the judge has a greater duty to justice, in which case the judge may have to seek some clarifications just to ensure that they understand the case fully and that they don't remain completely without an understanding of the case. So the judge can ask a few questions to seek necessary clarifications. But the judge will never descend on the arena of conflict so as to appear to have taken over a particular party's case and to be prosecuting it for that party. That way, the judge may cross the delicate line between seeking clarifications and being a party to the dispute. What should one consider when cross-examining an expert witness? I have observed that there is a book by Aya and Aya called The Art of Cross-Examination. There's an entire chapter in that book on how to deal with expert witnesses. In fact, the authors have been so studious that they have given us various categories of experts in various fields and how you can deal with them. So I'll not do justice to the subject, but I'll do some overview of just what you need to deal with. Number one, remember that that man or that woman is an expert in the area he's dealing with, and you are not. Remember that, just show some respect. That will tell you which areas you will go into in seeking details and which areas you will simply respect that expert, lest in your endeavor to go there, you begin looking like a fool. I'll give you an example. There's a man who finally died, and the death has nothing to do with the case I'm referring to. He was a valuer, a professional valuer, who had done a valuation of a house. It was an auction gone sour, and therefore we had filed a case in court to claim damages in the value of the house. And the advocate cross-examining this valuer, then he began asking questions that made the valuer tell him in answer as follows, that counsel, what you are doing is you are questioning the entire science of valuation. And the way we get value of a house is based on a principle in economics called the Pareto principle, that the entire thing has a value greater than the sum of the parts. So that if you want to get the value of an airport, you don't begin by asking how many screws were used to screw together this carousel, not that carousel, that thing that moves the bags at the airport. How many screws were put there and how many pieces of aluminum were put there? No, that's not how we get the value. There is a principle in economics how to get values of such capital investments. And it's not by way of adding the sum of the parts. How many bags of cement were put there? How many bulbs were put here? And how many drainage parts? No, that's not how we get the value. So respecting that science becomes important. Then number two, you then begin testing the logic supplied by this expert to the fundamental principles. The way I do it myself is just to humble yourself and talk to some experts in that area. So you get a pathologist report on the cause of death. You just take this report itself to a pathologist who is a friend of yours, a friend of your client, and then look at it and tell whether it complies with the fundamental principles. Some of them may tell you, no, there's a problem. This person didn't do 1, 2, 3. So in your cross-examination, you begin by establishing whether doing 1, 2, 3 is an essential part of a pathological test or examination. If the witness confirms it is essential, you then confirm, no, your report shows you didn't do 1, 2, 3. If it confirms, you're finished. It shows the report is not credible. The report is not reliable. The report is not founded on fundamental principles of pathological tests or examinations. So just getting that second opinion or third opinion from an expert in that field may be helpful to you in getting it right. Otherwise, I keep telling people, don't be too long with the experts. What are you examining them on? You're not their trainer. And that's not your area. Be very brief and to the point with the experts to go to what you want to show the court so as they don't believe that area. I'll give you an example of a cross-examination I did in Kitale. It was a handwriting expert, well, a formal trained handwriting expert who had prepared a handwriting expert's report to show that my client's signature was a forgery. The signature on the document was a forgery. The person whose signature is said to have been forged was dead, had died well before the case started. So we could not call them to confirm anything. They were dead. But we had information that that person had suffered some mild stroke long time ago. and stroke affects handwriting. But the information given to the expert, remember the expert is not there when the person is putting their sample writing. Somebody collects the sample writings and carries them to the expert. So the expert in their lab or in their studio, whatever else they do the expertise, studies the handwriting. So I asked the expert only one question: does a stroke or any other disease of that nature affect handwriting? He says yes. If you had known that this person had a stroke, does that potentially affect your opinion on the handwriting? He confirms yes. Did they tell you this person had stroke? He says no. He could not say yes because a handwriting expert produces a report, and the report has to capture all material aspects. So if they had told him or her that this person has suffered a stroke, that would have been in the report. So the moment he confirmed that he didn't know that this person had a stroke, that became the end of that story, because we had doctors' reports, those doctors who had treated this person of stroke, which we were going to introduce through other witnesses to confirm the person had stroke. And once we confirm that, then this report becomes completely unreliable. So that's how you deal with experts. You don't go questioning their science. Many of them will readily confirm what you want them to confirm. Like when I asked this fellow whether a stroke would affect a handwriting, many experts have no dog of their own in the fight. No. So they'll confirm these facts. And they'll confirm, no one told me this fellow had a stroke. Then they'll go home. They have been paid for their service. They have been paid to attend court. They have nothing they are losing. And they're just doing their work as professionals. So that's how I would approach that. How to manage objections from opposing counsel to avoid losing a train of thought. Number one, avoid asking objectionable questions. So ask the correct question yourself. And the person will not object, because to object, there must be something objectionable. And if they object when there's nothing objectionable, and they object again when there's nothing objectionable, and they object a third time, the court will caution them. And that way, they will suffer psychological beating themselves. In fact, at that point in time, you acquire some rights to throw some jab at them that may humiliate them a little more. And that way, psychologically, they look beaten. So ask the correct questions all the time. None of us is so perfect that we never ask the wrong questions. No. If I review my own clips on cross-examination, I can pick multiple instances where I ask the wrong questions. Just the nature of this work is you slide at some point in time. Just don't make them the dominant theme in your cross-examination, and that will help you. But otherwise, where against your best endeavors, you are still confronted with multiple objections, just remember, keep calm, compose yourself, and do the right thing so that you don't lose your train of thought. Those are the 3 questions. And any other questions from the online platform?
Maybe last 2 sets of 3.
Okay.
Okay. The second last set, we'll combine a question from Ms. Kayugira and Mr. Buchi. Can you describe a witness that was very difficult and how did you crack them? Combine that with, can you share an example from your career where cross-examination significantly altered the outcome of a case, and what lessons can be drawn from that experience for both legal practitioners and law students? Second question in that set, how long does it take a young lawyer to become a great cross-examiner like Elisha Ongoya? And lastly, I have noticed young counsels are treated differently by judicial officers, sometimes to their disadvantage. How then can a young counsel become more effective in trial advocacy despite the prejudice?
Okay.
Prejudice?
Difficult witness and how I cracked them. Every case to me is like my own baby, like my own child. Every case, when a client comes to me with a case, it's like I've gotten a newborn baby. And we all love our children, isn't it? Is there anyone here whose parents hate them? And therefore, anytime people tell you to then isolate. It becomes very difficult. You begin thinking across all your children and trying to see how do I isolate the attributes of this one from that one to see whether I can get an element. I'll combine the first and the second question just by picking a few case scenarios that I've dealt with, so that our listeners can then see what lesson they can pick from those cases. Let me give you a very simple case, for example, that I handled when I was very young in my career, of a young girl. I am a young girl who is working as a receptionist at a hotel. She's a receptionist at the hotel. And, you know, hotels have these pigeonholes where you can keep your luggage. Those of you who have spent time in hotels know that you must check out of your hotel by 10 o'clock in the morning. So you check out, but your flight is at 3 p.m. It means you must have a place you can keep your luggage pending your trip to the airport. So this hotel in Nairobi had a place where customers would keep their luggage. Then you pay some 50 shillings. You have to have your luggage kept there. Then in the evening, you pick it and go to the airport. Then after some time, the hotel realized that it was not receiving this revenue. The staff at the reception, I think, were pocketing this revenue. So it arrests all staff who have ever served at the reception in various shifts, the 5 of them, and takes them to the police station for theft by servant. Then the manager goes to the hotel. Cumulatively, after 2 years, those staff had stolen 2,650 shillings. The amount of money the 5 people were accused of stealing was 2,650 shillings. When I teach legal theory, I always ask my students, if I came to this class and stole your big biro pen, is there a risk that I'm going to be prosecuted? And the answer, no. Why? Because it sounds useless to report somebody that they stole your big biro pen to a police station. But this hotel reported that it had lost 2,650 bob to its 5 staff who had worked at the reception desk. Anyway, the manager went to the police station and asked the staff that if you accept that you have been stealing this money, I will let you go. But if you continue denying, I will ensure this case goes to fruition. Out of 6 members of staff, 5 accepted that they had been stealing this money. And true to his promise, they were let go. 1 said, you know, I have never stolen anyone's money, and therefore I am not accepting. She was actually prosecuted. So my cross-examination was centered on only one question, on one theme. The police and the complainant know the thieves, and they have let them go. They know who the thief is not, and they are prosecuting that one. Can there be a worse of abuse of the legal process than that? So the questions always brought out this theme. You know the thieves, and there are 5. They say yes. Those ones you have let them go, yes. This one is here because she had said she didn't steal. Had she said she stole, she would be a free citizen out there. She said yes. So that let that lady off the hook. I'm answering the question where cross-examination has significantly altered the results of a case, and true, that case was one. There's an ongoing case, so I'll not give you the name of the case, but you may search online and you'll see some of these attributes. I dealt with a case where a witness had been brought in to fix my client. As a matter of fact, and I believed my instructions here because sometimes I believe my clients, many times I don't. A few times I believe my clients. As a matter of fact, this witness had never witnessed what he says he witnessed. He was not there, as a matter of fact. But he was arrested, treated as a suspect, given a statement to record implicating my client, and he recorded it. And I got this witness through cross-examination to disown a bulk of his story. Disown it one by one. Disowned one. I asked my second, he disowned another story. Another question, he disowned it. So eventually, I got him to answer a question whether if he was the judge, he would believe his own story. And he said, I cannot believe that story if I was the judge. His own story. So if you went online and search a Google search on Ongoya gets a witness to say he can't believe his own story, you'll know who that witness is. We were able to crack that witness. He had come to court very defensively. Remember, there's a witness who is hired to do a job. And he had come to court to do a job. And he did it. I suspect that those who asked this question may have thought that I wanted to say Mutuse was that witness. No, he was not. Mutuse was my college mate. He's a friend up to now. Up to now, he remains my friend of mine. And he performed fairly well in my humble view. And this is a very honest view. He did fairly well under difficult circumstances. So it's only the circumstances were difficult. The witness was a good man, just under difficult circumstances. How long does it take a young lawyer to become a great cross-examiner? As long as they are willing to make the sacrifice. As long as they are willing to practice. As long as they are willing to walk under the wings of a mentor and be mentored. They will take a very short time. As long as they are unwilling to learn, as long as they are unwilling to subject themselves to mentorship, as long as they are unwilling to practice, they could be in this profession for longer than Dr. Haminwa has been, and they will never become good cross-examiners. That, to my mind, is the prescription. Young counsel are treated differently. That is actually true. Fortunately for the young counsel, all of us have been young counsel before, and we have been treated that badly. But that has not stopped our career path. The senior-most counsel whom you think is treated better differentially, and who you think therefore has an advantage, was once young counsel and was treated just as you are treated. But that didn't stop him from becoming senior counsel. That didn't stop him from becoming better counsel. So what am I saying? I am not encouraging judicial officers to treat young lawyers badly. In fact, I frown upon it. I encourage judicial officers to regard themselves as mentors and to treat every young lawyer who appears before them as mentees in need of mentorship. My very first criminal case, very first in my career, I appeared before court, and witnesses with those documents in my hands, and I walked with those documents back to my chambers without producing them as exhibits. Eventually, they declined one day. I wonder why that judicial officer didn't remind me, counsel, perhaps you want to produce those documents? Maybe I would have known I'm supposed to produce them.
How would an advocate deal with his own witness when he or she turns out to be hostile for the cross-examination to have his case a success? And I'll connect that to another question that was shared virtually. How best to adapt on the spot when a witness completely unravels your planned line of questioning?
Okay.
Lastly, from Edon, did the CJ act in good faith in presiding over the swearing-in ceremony of Honorable Kindiki as Deputy President? The aggrieved party had not exhausted the appeal mechanism. In any case, this is a matter the Supreme... my apologies. The Supreme Court should have original and final jurisdiction. For governors, the appeals have been going all the way to the Supreme Court. Would you then agree that this was an abuse of the court process? To answer those two last questions, I'll give it back to Yugi, and then can perhaps, yes, wrap up the session for us.
Thank you. You know, I'm not the best commentator. I'm not the best person to comment on who acted right, who acted wrongly, who would have acted differently in the ongoing impeachment trial of the former deputy president, for the simple reason that I have a direct and vested interest. So because of that, I would intentionally avoid responding to the question whether anyone, not just the chief justice, but whether anyone acted right, or whether the interlocutor is right in his observations on how the CJ ought to have acted or not acted. I trust that our listener would understand where I'm coming from in avoiding to answer that question. What do you do when a witness completely unravels your plan? You plan better next time. You plan better next time. It just means your plan was not right. By the time it just means you completely misunderstood your case theory, because your cross-examination is anchored on your case theory. It means you had a false case theory. You misunderstood that witness story. And that's why he is able to completely get you off guard. But if you understand your case theory well, and you understand the witness's story well, and you juxtapose the witness's story against your case theory, no witness under the earth can defeat cross-examination properly deployed. I want to tell all lawyers, young and old, cross-examination is the most powerful tool ever invented by common law in the trial process. When your own witness stands completely hostile, what do you do to secure success? Let me caution my listeners, think of winning at all costs. Your duty as a lawyer, ethically speaking, is to do your best and leave the rest to the fact finder. And this is not your case. This is your client's case and your client's witness's case. It's their own case. If they come to court and insist that they want to destroy their own case, why would that worry you as a lawyer? If you're a doctor and you play your best possible sense of judgment and you give the patient the best medical prescription, and the patient says, I will not take these drugs, how does that bother you as a doctor? Your patient's file will show which diagnosis you had, which medicine you prescribed, which advice you gave, isn't it? That's all that you owe your patient. And that's it for us. Sometimes witnesses become hostile. The rules allow us to then ask for leave of court to now ask leading questions. So you can now ask leading questions to the witness. But remember, at that point in time, moving forward, the evidence that witness is giving becomes evidence of the least possible weight. It becomes admissible evidence, yes, but of the least possible weight. So it just means you then must rely on other witnesses to supply weight to your case for your case to have a chance of success. So that's how you deal with hostile witnesses. There's no other way. Otherwise, witnesses, like we lawyers, must just know that as civilians, as good citizens, they also have a duty to the cause of justice by giving correct witness statements, correct affidavits, so that when they come to court testify, they have no reason to become hostile, because what they are telling the court is their truth as they have always known it. People become hostile because along the path of life, they have tried to play with the truth. Had they understood their civic duty under Article 3 of the Constitution, they would just have done the right thing from the very beginning. There will be no incentive for them to then begin engaging in becoming hostile witnesses. I trust that I have tried the much I can to your online audience. Let me come back to our moderator here, so that he has many more questions for the cross-examiner. But he must remember, the cross-examiner is not best suited to answer questions. He's best suited to ask questions. I trust he will now wind down in the next couple of minutes to give the cross-examiner a chance to rest. Back to you, Mr. Oyugi.
Yes, I have one question, one last question for you. What advice would you give young advocates about managing court dynamics, especially when they may be cross-examining more experienced or well-prepared witnesses?
Thank you so much. In fact, that's a good question, because it gives me a chance now to summarize my closing lessons to all of you. To young lawyers, to students, you are investing in a career whose success is a long-term bond. The legal profession success is a long-term bond. You know these treasury bonds, isn't it? You can take 3-month bonds, you can take 1-year bonds, so they give you returns quickly. The legal profession is a long-term bond. You will cash it after a long term. And therefore, you must have that attitudinal entry in the profession so that you don't despair too quickly when the fruits don't look too soon, because you as a long-term bond and you'll get the fruits much later. That's number one. Number two, the maturity period for this long-term bond begins to run when you begin to invest in the profession. So you don't sit back idle, not investing in the profession, hoping that the long term is running. It's not running. It'll begin to run when you begin investing in it. So the time begins counting when you begin investing in this profession. This profession gives you fruits, but you must invest in the roots, which are almost invariably bitter, almost invariably. I've never seen sweet roots in this profession. So what does that mean? You must prepare, and the preparation begins now, where as a student, the diligence that you give to your assignment is your investment in your attribute of diligence that 15 years later will make you stand on the stage and defend the deputy president of a country in a war that he has with the president of the country, in which case you will fight against the cause of the president of a country. That the preparation then begins now. By how diligent are you with your class assignment? How diligent are you with your group work? When the members of your group say, we are distributing this group work, you go and research on this definition, you can look at how diligent are you with your returns? How honest are you with your work? Because again, I want to tell you, your success in this profession is dependent significantly on your honesty with this profession. How honest are you in this profession? How much are you investing in honesty? How much are you investing in your reputation? People must begin knowing you for being a studious person, for being a diligent person from the very beginning. These attributes, you will improve on them as you get by. But you must begin planting them now. You should have begun yesterday. Your next best opportunity is now. You'll reap the fruits of this profession definitely 10 years later, 15 years later, 20 years later. You'll reap the fruits. I have sat with Senior Counsel Paul Kibugi Mwite in the ongoing trial of the Deputy President's case. And he has put in 55 years in this profession. 55 years. I admire the advice he gives when we are in that preparation room, thinking that our world is crumbling on us. The things he tells us and we wake up re-energized, I admire them. And I believe it is the cumulative investment of 55 years that makes him take that posture and that position and keeps us guiding us along this path. Your 55 years must begin running today if you begin studiously investing in. If you want to have some fun of lack of seriousness for the next 30 years, your 55 years will begin running 35 years from now when you begin investing in this profession. So bottom line is, let us remember, we belong to a profession that is about some ideals. We are the custodians of those ideals. Ideals such as justice, ideals such as the rule of law, ideals such as constitutionalism are in exclusive custody of those of us who have subscribed to membership in this profession. If we regard those ideals as important, we must invest in them. It is not possible to invest in those ideals through dishonesty, through lack of ethics, through lack of values like hard work, like regard for other people's dignity. We must invest in all these ideals. Once you do that, as a young lawyer, as a young advocate, you will manage the dynamics of court and the dynamics of industry seamlessly. I rest my submission.
Thank you very much for your Okay, for your participation in this session. It's actually an opportunity, or actually a lifetime opportunity. It's rare. So we have to acknowledge you for that. Thank you so much. Thank you so much for our audience for coming. It's not easy also for moving from Rafiki to get here and all that. And also for our online audience, thank you so much. We're humbled. I think we have come to the end of our session. Yes, you can have Anne giving us her closing remarks.
Mine is just to echo what Oigia said, to thank you for joining us, to thank you, Mwalimu, for your time and for sharing with us. We are ever truly grateful. We do not take this for granted. Thank you so much to our online audience. I believe we got at 421 members. So we appreciate all of you. Want to acknowledge the presence of our Dean, Professor Ambani. Thank you for joining us. And all participants, including Amwengi Mutuse. Yes, he was among the audience. Not sure if that is Mutuse, but yes, we thank you, all of you, our participants, for joining. Perhaps we'd share, the words of the grace, and then we'll be free to leave.